respect of, in particular, Mr. Ntanzi, is that my instructions are to object to the recalling of Warrant Officer Ndlovu and denying the state to adduce these additional photos, especially in the context for which the state seeks to introduce them, i.e. to cross-examine, to re-examine Colonel Gininda on the description and the identification. And particularly, my lord, let me go to this. At paragraph 2.2, in fact, before 2.2, my lord, there's a passage that is very, very germane. Yes, at page 5 of the head of argument, the state went to length to quote a passage where I had an interaction with Brigadier Gininda. And in particular, I remember vividly what the interaction was all about, my lord. I was put to Brigadier Gininda in respect of what the witnesses in the house, some of the witnesses in the house described the second intruder. And my submission to him was that all of the witnesses in the house, when they spoke to Warrant Officer Steenkamp of the facial identity kit section, the facial identification unit of the SAPS, they never described how the second suspect that entered the Khumalo household looked like. Now, if the exercise of the photos, according to the state, is to then canvass this issue, my lord, we are going to make the following submissions. At paragraph 2.1 of our heads of argument, to say the 16 or so photographs that the state seeks to introduce are not new evidence. These photos, at the time Warrant Officer Ndlovu testified initially in this case, we were told that download analysis were done on the SIM cards and the SD card belonging to accused or Mr. Ntanzi in respect of those devices being found in his Samsung cell phone. Now we are saying, my lord, at 2.1 that the state had ample time at the time to lead Warrant Officer Ndlovu on the totality of all the photos that were germane in their examination of Warrant Officer Ndlovu at the time, not as an afterthought. If the state, my lord, we submit, were using a stratagem that we are leading this, we are leaving this out as a strategy, not as an omission, not as an oversight, not inadvertently, then we are saying, my lord, they must lie on the bed that they made. They adopted a particular strategy. Now they come later and quote Hepworth. Hepworth does not assist the state, my lord. Hepworth says an omission by another party should not be taken advantage of by another party, my lord, in proceedings. And Hepworth also deals with the duties of the presiding officer, who we are told is not an umpire. He directs proceedings to make sure that justice is not only done, but justice is seen to be done. So we are stating, my lord, still at paragraph 2.1 of our heads of argument, that nowhere does the state state that there was an oversight on their part, there was an omission on their part, and as Advocate Munisi correctly stated in his submission, at paragraph 2.3 of the state's own is the reason why, and I quote, the reason why was not presented only during the long adjournment that was afforded to Advocate Munisi to prepare his cross-examination, that over 5,487 photos of the downloads These downloads were given to the defense a while already. The state has extracted 3 additional photos from the downloads, including a single photo of accused number 1 that we want to show the court. Accused number 2 and 3 do not dispute that the cell phones and the SD card from which the downloads were made belong to them. The photos belong to them, including the single photo of accused number 1, and therefore fall within their knowledge. We therefore submit that they will not be prejudiced. I'll come again to this point, my Lord, when I argue a different aspect, but I want to go to my second point on my heads of argument, my Lord, to say that, my Lord, in our view, this is cumulative evidence, which is unnecessary and prejudicial to Mr. Ntanzi. We further argue, my Lord, that the state seeks to have a second bite at the cherry when they had ample time to do so during the initial testimony of Mr. Ndlovu. And this is meant just to put, as the state puts at paragraph 2.2 of their heads of argument, to say these additional photos are to show further appearances of accused number 2. It's got nothing to do with the re-examination of Brigadier Gininda on the aspects we engaged on regarding the identity kit compiled by Warrant Officer Steenkamp. And, my Lord, we quote the case of S. Green, 1962, 3SA 886T at 889, where the Judge of Appeal, Ogilvie Thompson, stated that an application of this nature, that is, recalling of witnesses, may also be refused, and to quote, to exclude irrelevancies and discourage repetition, and I close. And my submission, my Lord, is that the photos that we've been supplied with of Mr. Ntanzi, it's a repetition of how he looks like. And the burning question is how he looks like in 2014. We don't know how he looks like in 2014. We don't know the date of those pictures pertaining to the date of the incident that this court is concerned with, my Lord. And we further quote, my Lord, the case of R versus Ghani, a 1958 case, 1 SA 102 AD, where the court held that, and I quote, a trial court must be accorded all powers to control the length to which the parties must go into investigating matter of a subordinate nature on the fringe of the case. It is important that a trial should not be unduly prolonged exposure by an over-elaborate examination of minute details which cannot materially affect the central issue. The central issue, my Lord, here is identification, and identification by who? Not by Brigadier Gininda, but by the witnesses that were inside the house at the time the offense was committed. And that description and identified as given by the very same witnesses 3 days later or 2 days later, on the 28th of October 2014, after the commission of the offense, to a person, an expert in the SAPS who deals with identification, facial identification, being Warrant Officer Steenkamp. Now, at 2.3 that I've referred to as an anecdote, the state states, we therefore submit that there will be no prejudice to the accused persons by submitting this evidence. And it ends there. My Lord, prejudice is one of the factors that the state should have gone into some length, because This matter, my lord, has dragged on, and the prejudice to the accused persons, all parties involved, the families of the deceased, need to see this case coming to an end. And recalling this witness simply to give additional photos that add no value to the issue germane to the identification of accused or Mr. Ntanzi in particular, serve no purpose, my lord, and prejudices the accused persons, all of them, the 5 gentlemen before this court, extensively, my lord. Furthermore, my lord, at paragraph 2.4 of our heads, the state sought to base their heads of argument on section 167 of the Criminal Procedure Act. I respectfully submit, my lord, that reliance on section 167 of the Criminal Procedure Act is misplaced. Section 167 is the purview of the presiding officer, not the state, not the defense. The defense and the state can apply for recalling of witnesses that have testified that are present in court, but using a different mechanism, not 167, my lord. And I'm not going to read 167 for the court. All of us who are here are well aware of the provisions of section 167, my lord. At paragraph 2.5, my lord, we submit respectfully that the issues relating to the identification and the description, especially because of what the state says I put to Colonel Gininda regarding what the witnesses said to Warrant Officer Steenkamp, I submit the following, my lord, that these are issues that are matters of credibility that the court is seized with at the end of the case to determine on the credibility as to the description of the witnesses in the house, the description as proffered in their evidence in chief in cross-examination here in court. Re-examining Brigadier Gininda on those issues is not going to change what those witnesses told Warrant Officer Steenkamp. The other issue, my lord, that we addressed in our heads of argument is the reasons why that evidence was not led in chief. And I submit humbly, my lord, that I've already traversed this, and Advocate Muniz as well has traversed this. There's case law anecdotal at the end of the state's heads of argument which deal with the interest of justice, and we cannot follow those cases. Multi-choice, all of those cases, my lord, we are well aware of those. But the interests of justice, my lord, are a two-way street. So we implore this court to prioritize fairness, efficiency, and the interest of justice, my lord, in deciding the very fact that we are debating here in court today, my lord. And lastly, my lord, at the end of our heads of argument, we reiterate the same position, that is the right to re-examine by either the state or the defense or by the court, my lord, for that matter. And that are the provisions of section of the CPA, my lord. I'm not going to regurgitate those, my lord. We during our debates previously, my lord, we had traversed those issues. As the court pleases, my lord, that will be my submission, that the court denied the application to recall these witnesses, my lord, and to lead further evidence of Mr. Ndlovu in particular regarding Mr. Ntanzi. As the court pleases, my lord.
Thanks. Yes, Mr.
Thank you, my lord. I will have no submissions. I will have no submissions. Thank you.
Thanks. Yes, ma'am.
Thank you, my lord. My Lord, I have only 2 submissions to make, my Lord. On the objections raised by the defense in the inclusion, my Lord, of the new evidence. My Lord, as my learned friends have submitted the reasons that needs to be considered on this application, and one of the reasons, my Lord, is the delay, reason for the delay in leading or in introducing the evidence that a party intends to introduce at this stage. The reason, my Lord, which I found on the heads of the argument submitted by the state in respect of accused number 2 is that the state only had an opportunity to go through its own evidence, which is 5,467 photos. And it's only then they realized that the state wanted to introduce this evidence when I read through the heads of the arguments of the state, my Lord. My Lord, my submission is that so it means the state, at the time when the state was supposed to furnish the defense, in particular accused number 2, with further, full, and better particulars in order to enable accused number 2 to prepare his defense, the state did not comply with those provisions, because the state is saying, my Lord, on its own heads of arguments, they only had the opportunity to go through the evidence during the adjournment when Advocate Mnisi was preparing for his cross-examination. That on its own, my Lord, it shows that the state was reckless in reading and analyzing and preparing the evidence that the state wanted to introduce, that the state wanted to use against accused number 2. It shows that the state from the outset never intended to use the information or the evidence that they now intend to introduce, because it was lying in their hands, but they elected not to introduce such evidence, my Lord. And therefore, that on its own has violated the rights of the accused to a fair trial, in that he had not been afforded with an opportunity to prepare his defense case from the outset of the trial. Therefore, the inclusion of this evidence, my Lord, will affect the right to a fair trial of accused number 2 on the basis of the reason that has been submitted by the state. Then on the part of accused number 3, my Lord, also on the reasons for the delay, the state on its own heads of argument, my Lord, indicated that it is the investigating officer who picked and chose the photos that were supposed to be included in Exhibit S, which was presented before this court. Therefore, it means, my Lord, at the time when the state was preparing the evidence, the state was in receipt of this evidence, and therefore it was the issue of the investigating officer to pick and choose which evidence to be presented and which evidence not to be presented against accused number 3 in respect of the pictures that the state had at the time when they were preparing Exhibit S, my Lord. Also, it means, my Lord, the state was negligent on their part. Also, my Lord, it goes further to say also the state has failed to give accused number 3 the evidence, or to furnish, not to give, my Lord, to furnish accused number 3 with further, full, and better particulars in order to enable accused number 3 to prepare his defense case, my Lord. Now, the introduction of this new evidence at this stage, my lord, will be prejudicial to both accused because the reason submitted by the state for failure to include such information at the beginning, it shows that they were reckless. The state was reckless, my lord, or did not pay particular attention to the evidence that they intended to use. My lord, I may submit that the inclusion of such evidence will be prejudicial to the accused, my lord. Those are my submissions only.
Thank you. Any response, sir?
As a court, please, my lord. Well, firstly, as far as the arguments of Advocate Nisi and Mr. Ramasipele is concerned, there appears to be a serious misconception as to the reason why the state seeks to lead to the evidence, and we are saying this, my lord, with the greatest of respect. If one looks at the argument of Advocate Nisi, he mentions, for instance, that there's no valid reason as to why the evidence wasn't led through Brigadier Gininda. He also mentioned that there's no explanation as to how we missed the evidence. And if one looks at the argument of Mr. Ramasipele that the photos are not new evidence, that we perhaps are reviewing our strategy, that our strategy was to lead certain evidence, that there's no averment that there was an oversight or omission on the part of the state, that the state wants to have a second bite at the cherry, and that the evidence is repetitive or irrelevant. If one looks at those submissions, my lord, we submit that there's this fundamental misconception of the reason why the state seeks to leave the evidence at this point, my lord. And we've played open cards. We've come before the court and said this evidence, when we let Brigadier Gininda that the photos had not as yet been identified. We mentioned, my lord, in our heads of argument on Friday that it was during the long adjournment, and this we set out in our heads of argument that we presented on Friday, that it was, and this paragraph 2.3, that the reason why the evidence was not presented during evidence in chief is that it was only during the long adjournment that was afforded to Advocate Nisi to prepare his cross-examination that we were able to trawl through the 5,467 files. And we've come to the court, we've played open cards and said these photos were discovered, and I use discovered in the sense that we were able to identify those photos after the evidence of Brigadier Gininda in chief was led. So in other words, this evidence was not available at the time when, and I'm using the word available in the sense that the photos had not as yet been identified at the time when Brigadier Gininda gave his evidence in chief. Well, Advocate Mshololo then submitted that this is new evidence and mentioned that the state was reckless and that we did not furnish the requested further particulars. And as far as accused number 3 is concerned, she submitted that the state failed to give accused 3 or to furnish him with better particulars. The fact of the matter, my lord, is that the photos, as we've indicated, were contained in the disc that was given to all the defense counsel some time ago, and in our submission, my lord, this was sometimes in 2023. We don't want to commit to the year in case we are accused of not putting correct facts before the court. But this is a long while ago, my lord, that the evidence was furnished to the to the defense. I can put it as high as saying that even before the resumption of the trial, that this evidence was furnished to the to the defense. So they can, my lord, we submit with the greatest respect that they it cannot be argued that we failed to furnish further particulars when we furnish this information in a disc before the trial commenced. And my lord, as the trial unfolded, certain propositions were put to the witnesses, and in this regard, we just want to refer to a proposition that was put to Mr. Tumela Madlala. This was on the 8th of August 2023 on page 13, line 14, by Mr. Ramosepele. He put the following proposition: now, accused number 2 instructs me that he has never had this beard here. In fact, it does not grow on him, and he has never had an O-shaped beard like you say the second suspect had. And furthermore, that he has always kept the goatee, the one that you see here in court, from as long as he can remember. And my lord, these are some of the aspects that only came during the cross-examination of the witnesses. And my lord, the photos that the state seeks to hand up address these issues that only came to light during the cross-examination of the witnesses. The reason, my lord, why we quoted the passages that appear in our heads was simply to show relevance as to why we want to present the evidence. We therefore submit, my lord, that the state should be given the opportunity to lead this evidence. We have advanced the reasons. We've played open cards with the court, and we are of the view, my lord, that there can be no question of prejudice, my lord, because these are simple photos of the accused. How can a person be prejudiced by the way that he looks? Mr. Ramosepele mentioned the fact that the photos are irrelevant in the sense that there's no date as to when these photos were taken. But one thing is certain, my lord, is that these photos were taken before the arrest of the accused, and therefore, my lord, this will be relevant as far as the period within which the offence was committed is concerned, my lord. We therefore reiterate that the state should be allowed to lead evidence on these photos, my lord. Thank you.
What's the time there?
It's 11:15, my lord.
Okay, can you come back at the half past?